Hello, this is Kevin Thompson. I'd like to welcome you to the McGrath LLC IP webinar series for March 13th, 2013. Today's topic is debunking copyright myths. Today, we're going to be going for about 30 minutes. The recording and slides are going to be posted on the address shown on your screen, which is blog.davismcgrath.com/webinars, where you can also sign up for our webinar mailing list. For those of you who need Illinois MCLE credit, if you haven't already done so, please send your name and ARDC number to me. Those of you who registered for the live broadcast and need the credit, you probably submitted your ARDC number as part of the registration process. But for those of you who are watching the recording, you can still get ARDC MCLE credit if you send me your ARDC number and how you viewed the webinar. And also please send me your questions. So today we're going to be covering 14 different copyright myths. I'm going to provide some explanations about those myths and explain why those myths are false. And also there'll be time for questions. A lot of this topics sort of cross over into some stuff that we've covered in prior webinars, such as copyright basics. I certainly would encourage people to check that out if they haven't already done so. But we'll certainly try to provide as much explanation as we can. But obviously, if you have questions, please feel free to ask them. The software allows you to ask questions throughout. And there'll also be a question and answer session at the end. So for the first myth, people say I didn't see any notice, so therefore it's not copyrighted. Like somebody will see something on the website or something and copy it and saying I didn't see any sort of copyright notice. That is false. Notice is not required under current law. It used to be the case, but it's not been the law in the United States for many, many years. That used to be if you didn't publish without a notice, it went into the public domain. But that changed, I believe, part of the 1976 Act. So I would certainly, call that currently a myth. Certainly, a notice is prudent. It's a good idea to have a copyright notice on your works. It puts people on notice of your rights and would, therefore, it would allege, sufficient facts, to show perhaps willfulness if somebody persisted in copying if they saw the notice and still proceeded, or to debunk a claim of innocent infringement. But again, notice is not required under current law, so that's a myth. The second myth involves charging for what's copied. People will say, "Well, I didn't charge anything for it, so therefore it's not a violation. I didn't do it for profit, so therefore it's a fair use." And that's false. Let's say you have a friend who's got a movie and you want to get a copy of it. Making a ripped copy of it, it's still an infringement, even if you don't profit from it. Copyright's a strict liability law. There is no such thing as sort of a de minimis infringement. It's either an infringement or it's not. So what would certainly would come up would be it would certainly have an impact on the measure of damages, but still giving away a ripped copy is still an infringement. So again, myth number two, that if you don't charge, it's not a violation, is a false myth. The third myth, people see something on the internet and they think, oh, well, it's out there, I can copy it, it's in the public domain. And that's also false. Internet publication is no different than any other media. If you have a website with information that you'd like to copy, it certainly behooves you to look at it and seeing who the author is, and get permission from the author in order to proceed with the use of that particular piece. the same thing goes for other forms of publication as well. But you see it a lot on the internet. People claim just because it's out there, they think they can copy it and use it, and that's certainly not the case. The fourth myth is actually an interesting one. It's one that keeps cropping up from time to time. It's called poor man's copyright. And essentially the way it works is if you mail yourself a copy of the work, that gives you a post date on the envelope, and you can prove, so the myth goes, when it was created, and so therefore that's just as good as having a registration. And so that's this poor man's copyright that keeps cropping up, and that's false. Mailing yourself a copy of something has no legal effect. It certainly might possibly be able to show when something was created under the right circumstances, but how do you know the person didn't mail themselves a blank envelope and then seal something in it later? It's a conundrum there that the people who advocate this approach haven't gotten a way around. It just simply has no effect, but it persists a lot. People think that copyright is some exclusive thing that's difficult to do, and so they've come up with these substitutes like poor man's copyright to try to help help the small man get protection, but people don't really tend to realize that copyright is a relatively affordable thing to do. I mean, it only costs $35 to obtain a basic registration through the online system. The forms are relatively simple and are designed to, for authors to be able to submit their own works, for simple things, and these types of workarounds really truly aren't necessary. But again, this poor man's copyright, mailing yourself a copy of something gives you some sort of protection, is a false myth. Okay, the fifth one, I'll give you 3 examples here. They're all related. The first is, my use was a fair use. I didn't copy the whole thing. And the second is, I can copy all I want, so as long as I give them credit. And the third is, it's this, people look at the percentage of what was copied. It's okay to copy less than 10% of the total work is how you see this expressed from time to time. And these are all false. Just so you know, the amount of copying is a factor taken into the infringement analysis, but it is not true that you can copy less than 10%, just make some minor changes or something, and that could be a factor there. And fair use is a defense for infringement that we cover a lot. In one of our prior webinars, for the whole 30 minutes, we covered the topic of fair use. So it's a defense to infringement, and it is worthy of further discussion at greater depth, which we did in that other webinar. So certainly urge people to check that one out. But just because you didn't copy the whole thing doesn't make it a fair use. So, and then the second one is related as well. I can copy all I want, so as long as I give them credit. There's a difference between copyright infringement and plagiarism, and you can copy somebody's work in such a way that you've taken their expression such to be accused of plagiarism, as opposed to copyright infringement. Because you didn't copy the actual work, but you've copied sufficiently without giving attribution. That's a different thing altogether than copyright infringement, and certainly one of them could get you in trouble in an academic standpoint if you're, or there's plenty of examples these days of people publishing books in which they've plagiarized others, and so there's certainly plagiarism out there. It's still a problem, but it's not a copyright issue. And again, giving them credit has nothing to do with whether or not that something has been copied. Again, copyright is a strict liability statute. Either something you've created is an infringement, or it isn't. The sixth myth deals with the protections that come if you've got a copyright. There's certain doctrines that come up with other areas of the law, such as trademark and so forth, where people think that you've got to defend your work in order to protect it. You can't allow any infringements out there to succeed if you're going to be able to enforce your copyright against other people. And again, that's a false myth. There is no requirement in the law that you pursue all infringers. There's certainly a cost-benefit analysis that I certainly would urge people to consider when deciding who to sue and who not. You look at the impact on your work and the impact on the market for your work. Those certainly all factors that would go into determining whether something would be worth the fees and the expense of litigation. But there's no requirement that you sue everybody. So myth number 6 is definitely false. You don't have to defend it or lose it. The 7th one crops up from time to time. If I make a story based on someone else's work, my work belongs to me. And this comes up a lot in people will create a derivative work based on something else. Let's say hypothetically you really liked Sherlock Holmes and you wanted to create a work based on Sherlock Holmes, and using the Sherlock Holmes characters, and you can own your own copyrighted work in that piece. And so that's the hypothetical I'm giving you here, and that is false, provided that you don't have permission of the original author in order to do this. Derivative works such as like fan fiction we talked about are infringements that can't be owned without the permission of the original author. And so if you're preparing something that is a derivative work of something else, you really do need to get a permission of the original author in order to proceed with it. Certain examples such as Sherlock Holmes, it's actually been in the news lately. There's been some litigation over that because there are certain aspects of the Sherlock Holmes character, some of the first novels that are in the public domain, but some of the later works are still protected, especially under UK law. So it would be worthy of an analysis there of just what is protectable for Sherlock Holmes, but so that's probably not the best example. But this happens a lot. People will try to write their own fan fiction, like say in Harry Potter or in the Star Trek worlds, and these are technically infringements, some of which persist with the permission of the original author, such as the people that own Star Trek will allow certain types of fan fiction to exist as long as they're not sold for profit. So non-profit use is still okay, and others are out there that simply will crack down on everybody and will not allow any type of this work out there to exist. So this myth that you can these characters are out there, you can just use them, and as long as you aren't copying the original book, you're okay, is certainly a myth that is false. The 8th myth is certainly related to one of the first ones, but it's a little different, so I gave it its own number. If it's not registered, I can't be sued, is something that comes up from time to time. People think, well, you don't have a copyright registration, haha, I can go on and persist and do what I want to do, and that is false. You certainly do need a registration before you can bring a suit in federal court for infringement. but you can register a work after the infringement has occurred and still bring suit. And so, just because they don't have a registration doesn't mean you're off the hook. As we've talked about on our Copyright Basics webinar, there are special requirements if you want to get statutory damages and attorney's fees. You've got to register it within the first 3 months of publication or prior to when the infringement occurred if you want to get statutory damages or attorney's fees. But if you don't, you can still get other measures of damages. You could get, actual profits of the infringer. You can get your own actual damages. These types of things. So it is definitely a myth that if it's not registered, you can't be sued. The next one is the 9th myth. These two are sort of related. When I acquire a copyrighted work, I also acquire the copyright in it. And this is the next one is a related example that actually happened not that long ago. I found this photo in a storage locker of Elvis, and I want to sell prints of it. And so somebody had taken a photograph of Elvis and among other celebrities, and the one that was on one of these storage locker television reality shows, they found this picture, and now they wanted to sell prints of it. They thought they could just go ahead and do that because they had found it in the locker, and thought that just because they owned the physical copy, they could go on and do whatever they wanted with it, including distribute further copies of it. And that is false. When you acquire a copyrighted work, you acquire the rights to that physical copy, and you can do whatever you want with that physical copy, such as you can modify it, you can cut it apart, you can take the book and take it out of each individual page out of the bindings. You can sell that copy to somebody else. There's all kinds of things that you can do with that physical copy, but making another copy of it and selling that would be an infringement, and it is one of the exclusive rights of the author to control the distribution of the work, and so in the case of the Elvis photo, the original photographer, whoever took that photo, retained the copyright in that photo, regardless of the condition of finding the physical print. It doesn't matter if you had got the negatives. It's the fact that the photographer retains the copyright, and without some sort of a license from the copyright holder, going on with a business that makes copies of these physical prints, would be a risky business. The 10th myth is an interesting one. People see this happens a lot. Is people see a book that they want to make a copy of, especially for academic use. That there's a book that they want to use and put on reserve for a particular library class, and the book's out of print. They can't get enough copies of it. And so some people think just because it's out of print, it's in the public domain, I can make copies as much as I want and distribute it to my class. And that's false. Being out of print has no effect on whether or not the copyright in the original work still exists. Depends on the rights that were assigned from the author to the publisher. The publisher might be the person to contact to get permission. They may still maintain it. Other times it depends on the contract that they may have an agreement where the copyright reverts to the author once the book is physically out of print, and so you need to follow up with the author to try to get permission. And then the other possibility is that the author had the works all the way had the rights all the way along, and just merely licensed the publisher to print, and the author maintained rights. So you sort of need to follow up directly, with the author. This one comes up. People think of the digital book scanning project that Google did in the last few years, and where they went through libraries and scanned these works in libraries that were out of print, and added it to their collection, and part of the Google Books project. And one of the lawsuits arising out of that, deals with what are called orphaned works, which are works in which no one can find out who the copyright owner is, and what to do about that. I mean, it certainly happens a lot. With these older books, they're out of print. The publisher doesn't exist anymore. They can't find the author. What do? Do you take the risk? Do you go ahead and use it, and hope to, get permission later, or risk a lawsuit if you're trying to use something in a really prominent fashion. You could be, facing a lawsuit with a lot of damages if you've got a really successful, use based on something, and the copyright owner comes along and says, that's an infringement, and I want to be compensated for it. And so that came up in the Google Book Scanning project, what to do about these orphan works. That debate is still going on. They, tried to create a fund that Google would pay into, that would go to compensate the authors if they should ever appear. And my understanding of that is that's still an ongoing dispute. So keep your works out for that. But you'll understand. A little bit more about where that comes from if you do see references to it. So the 11th myth relates to, again, permissions. People think if it's in the public domain, if the work is old enough that it's in the public domain, I don't have to clear permissions, and that's also false. Just because the work may not be protected by copyright doesn't mean that there may not be other rights that would still apply. Such as trademark or right of publicity. There's plenty of other things to be concerned about. Trademarks can persist in perpetuity as long as they're used in commerce to identify the source of particular goods or services. Rights of publicity are certainly limited by different state statutes. Some of them 50 years, some are longer. We talked about the rights of publicity in our prior webinar on that topic. And we've also covered, the trademarks in some of the other prior webinars as well. So, if you're interested in those topics, I certainly would, urge to check those out. The 12th myth is that copyright protects my ideas, or that copyright can protect my name or the title of a work I've made. And this is false. Copyright doesn't protect the idea itself. It doesn't protect the methods, the systems, short titles, blank forms, all sorts of types of things. What it does protect is the expression. So the example I like to give is if someone has thought of a book dealing with a young wizard that goes to school and learns about how to be a wizard as he progresses through the years in school, that itself is not a protectable idea. It's a general season unfair. It is the general idea of this is not protectable. There isn't enough detail there in order for there to be protection. But when you start adding details, like he's got a scar on his forehead, his mother and father were killed by this evil wizard, he's being shepherded through school by an older wizard who's the headmaster. These are more protectable elements that protect the expression of the idea that would protect J.K. Rowling's Harry Potter work. But the general concept of a boy wizard going to school is not protectable. And in fact, J.K. Rowling has defended her idea from her expression from similar lawsuits over the years, several that I'm aware of, in which people have written books which were also dealing with boy wizards, and they thought they weren't being infringed by the Harry Potter franchise, and she was successful in defending her expression. So, this happens. But it's a myth. Copyright doesn't protect your idea. Just because you've come up with it, doesn't mean that it is protectable. A related concept in copyright law is the sweat of the brow doctrine. Somebody thinks just because you went through a lot of work to create something that it is it's protectable because you put all this work into creating it. The example comes from the Supreme Court Feist case, F-E-I-S-T, in which there was a lawsuit dealing with a publication of a telephone directory, and this one company created a telephone directory, and it had been copied by another, and so they sued over the creation of it, and they ended up taking the case all the way to the Supreme Court, and the Supreme Court ruled that the telephone directory wasn't protectable. There was not enough sufficient originality in the collection, selection, arrangement of the works. Just because you put a lot of effort into it, the sweat of the brow into creating this telephone directory doesn't mean that it's protectable. And so there was no protection, and so the original publisher lost. So that myth number 12, copyright protects my ideas, or the name or the title, is false. The 13th myth is that song lyrics aren't protected by copyright. And you'll see this a lot. People will say, well, I can freely copy the words. They'll put up a website in which they have, copied the lyrics out from a particular song, and, put up a lot of advertising around it to try to, people type in the keywords, trying to find information on the song, and, lead to their website where you see their ads, and they get some revenue from the song lyrics, and so they'd say, well, that's not protected by copyright. That's just out there. It's not a protectable thing, and that's false. Song lyrics are certainly protectable as a means of written expression. It usually is registrable as a textual work. They have a separate copyright, separate and apart. People may not realize this. That's why I thought this was a good one to talk about, is that a piece of recorded music has several different copyrights that are associated with it. The lyrics could be one copyrightable element. The recorded music could have another. The actual sound recording could have one protection, and then the sheet music could have another one as well. And so those are all separate copyrightable elements, and so this particular myth that song lyrics aren't protected is false. And then the 14th is it's a myth that happens. So my use was okay. It was just free advertising for them. I don't understand why they're upset. They should be happy that this work is out there, and I don't see what the big deal is. They're getting all this free advertising. Well, why shouldn't they just go away? And that's false. And this comes from one of the basic rights that comes to the author through the Copyright Act, which is the right to control distribution. It's not your choice to make, how their work should be used. And the example I like to give is the original Calvin and Hobbes comic strip series. I don't know how many of you are familiar with that. It's a classic series of comic strips Calvin, the young boy, and his stuffed tiger Hobbs, who he everybody else sees him as a stuffed animal, but Calvin sees him as real, and he interacts with him, and it's really cute, and it's definitely protectable work. But the author, Bill Waterston, did not want commercial works to be made from his creation, and so the only thing you can ever buy of Calvin and Hobbes that's an official work are the books in which the comic strips are published. There's plenty of merchandise out there with T-shirts, bumper stickers, some of them PG rated, some of them a little more explicit. Calvin, uses of Calvin on some truck decals, or Calvin making a derogatory action toward a Chevy logo, and people might put that on a Ford. Those types of things, but none of those are authorized works, from the author. Those are all infringements, and that's something that the author Bill Waterston has certainly struggled with to try to control. But it comes. I think a lot of it comes down to people see it and they think that they're fans of it. That they want to express their love for that particular work, but it's not a form of distribution that was authorized by the copyright creator, and so it's technically an infringement. So so that gets us through all 14. I do believe we have a question. This would be a good time if you have a question to be asked. Now would be a time to do so, you can do those through the software. And those of you viewing the recording, if you would like to submit your questions, you could do so through the phone number or the address shown on your screen. Let's see here. This question is from someone that's merely wanted to obtain a copy of the PowerPoints. I'll go ahead and for that person, I know who it is, and I'll make sure they get a copy. But the slides and so forth will always be posted at the address I've shown before on the screen, which is blog.davismcgrath.com/webinars, it'll be posted with the recording there. Are there any other questions? Well, not seeing any, I'll go ahead and thank everybody for coming. Again, the recording will be shown on the address on your screen, which is blog.davismcgrath.com/webinars, where you can also sign up for a mailing list. And for those of you who are viewing the recording, please send me your name and ARDC number and how you viewed the webinar, and we'll endeavor to get you credit. We've applied for credit. We have not yet received approval, but I certainly anticipate it coming, and we'll certainly let you know if, for whatever reason, that falls through. But we haven't had one not confirmed yet, so no reason to doubt that we'll do that. So I would like to thank everybody for attending, and stay tuned. We'll announce the date for our next webinar shortly. Thanks, and have a great day.